All right, let's proceed.
Good morning, Your Honor. I'm George West for Nautical Tours. May it please the Court. The matter is before the Court on appeal from the decision of the single justice affirming the decision of the Department of Public Utilities. That decision has to do with the request by Nautical Tours that the Department of Public Utilities conduct an appeal or review of the denial of a municipal street license from Boston. Nautical Tours is attempting to have a amphibious tour company operate out of Cambridge. It does have some of its tours proceed through Boston. It enters the waterway and then it returns out of Boston into
I'm sorry,
Cambridge.
finish your sentence.
Just as background.
I'm just wondering, what did you do after the DPU sort of gave its conditional whatever? What did you do with respect to the police commissioner?
All right, Your Honor, that seems to be a bone of contention in the decision. And what they did was they wrote to the commissioner, they wrote to the legal counsel, and that is reflected in the letter that was sent to the, recall, first of all, that there was no hearing allowed here, so there was no record that was allowed to be built up to show these things to the Department of Public Utilities. But there was, in fact, a letter written to the department which set forth, and it's in the appendix, where they set forth all the steps they had tried to do. It's the February 11th letter.
Not very illuminating.
Well, it's limited. I agree with you. It's the only piece of correspondence that was allowed out of or requested out of, other than the application, Nautical Tours.
But there is a, as I understand it from statute or the act, there is, if the police commissioner doesn't act or denies it, there is a certiorari review, right?
That may be so, Your Honor, but that wasn't the contention of, that wasn't the contention that they had to get that site.
Didn't they have to get that or a waiver?
In the original petition, they were supposed to get either the sightseeing license or a notarized letter from the police commissioner that said that they didn't need one.
Right.
After pursuing the notarized letter, or actually just asking the police department whether they needed one, the police commissioner whether they needed one, they never heard back. And that, I just want to answer your first question. That's at, from pages 92 to 95. There is some support just in that letter, and I agree with Justice Cordy that it's not a lot, but it does state in there that they tried to get the waiver letter and they couldn't get it. It's on the second page. But in the interim, they learned more about the process, and they learned that for example, Justice Spotsford, that the duck boats, I should say the double-decker bus case, was able to get the very same relief that's being sought here without having that letter from the police department. And they were able to go to Boston and get the municipal street license, well, it was originally denied, and then they appealed to the DPU. They were able to follow that procedure and obtain it. And once they understood that to be the case, they did the same thing. They applied to the city of Boston for a municipal street license. And it's our point of view that once that choice was made, and by the way, it didn't appear to be precluded.
Which choice? I'm sorry.
The choice to go to Boston City Council and seek a municipal street license. That choice was not precluded. In fact, it was listed as an alternative step that was allowed to meet the Boston condition as we identified them.
Right, but what do you say about Section 3 of the Act? The police commissioner for the city of Boston shall have exclusive authority to license in said city, sightseeing and...
All right. That has been interpreted, as you know, because you read the brief and you've seen the double-decker bus decision, and Captain Sweeney has offered, out of the Hackney Division, has offered testimony in various settings that that does not apply for the closed-door type operation where you're passing through Boston, but you're not picking up, you're not dropping off people, you're passing through locations in Boston. And that was how, the double-decker bus case obtained permission or got licensed, I should say, by the
Right,
PCU.
but my memory is all they were doing was crossing over one of the bridges in Cambridge and then turning around in
Your Honor,
Alston.
that is an argument that the DPU is making here. The point, but it's difficult for me to understand how jurisdiction, that basic core concept, you know, is limited or has to be defined by the extent of which someone uses the relief.
Okay, but what is the response to, maybe double-decker was wrong, but does that mean two wrongs make a right?
Well, it's interesting. Was double-decker wrong? That they're saying now that double-decker was wrong. First of all, it would have been nice to be able to have a hearing before DPU and brief that issue and try to get the police record of consistently interpreting this provision of the 1931 Act on the record so it could be argued in the appropriate setting, it seems to me. But none of that was done. So fast forward to now all of the actions they've taken under that act up until this case have been wrong, and they don't have jurisdiction. I mean, it seems to me that they have consistently interpreted that.
Do you have more cases than double-decker?
Well, the double-decker is the prime case, I should say. So, but I mean, it seems to me that they have said this very clearly in the division, that in multiple settings, not only, they said it in a Boston hearing, they said it in the DPU setting for the double-decker bus, that it was not within their purview to regulate these buses that are coming and going in and out of Boston. They were regulating the buses, it seems pretty clear, that originate in Boston, travel through Boston, from, and presumably let off in Boston.
I'm really confused. This sightseeing license, does any other city in town give a sightseeing license or just a street license?
It appears that from everything you can learn about this, and there isn't a lot on it, but that all the other cities and towns issue municipal street licenses.
Okay, so.
But there's this other thing in Boston called a Boston sightseeing license. And they also have a municipal street license. By definition, they have two things.
You need both. You need both
Well, you
or a
need one or
waiver.
the one seems to subsume the other. If you get a sightseeing license, then you've got a municipal street license.
Oh, okay.
Oh, that's, and even though there are different authorities that are issuing the licenses, I see. So that's your understanding?
That's my understanding
But
of
it doesn't work the other way, right?
Well, if you
In other
get,
words, you can't, getting a street license doesn't mean you don't need to get a sightseeing license.
it doesn't appear so in Boston only.
Yeah, in Boston only.
But in
Boston.
all other municipalities, it seems that that's okay, that you'd get.
But is that not, I mean, that's rational. I mean, there's a lot more to see in Boston than there would be in
Worcester?
Waltham. No, maybe not Worcester, but Waltham.
Double-decker, Your Honor, says there's a lot more to see in Cambridge.
Well, there's a lot to see in Cambridge, I understand, but I mean, but Boston is sort of somewhat unique in terms of the density of the city, the width of the streets, the amount of sightseeing. Why can't they say?
Well, that's Reardon, and Reardon basically affirms that there's an interest in Boston that can be governed by the Boston Commissioner, so that's an okay thing for them to do. But it doesn't destroy the jurisdiction. I mean, you can't extrapolate Reardon as being a jurisdictional bar for the Department of Public Utilities to review both those licenses, certainly not the municipal street license, because 159A specifically says it doesn't have a subtraction for Boston, it's a general law. They were both made at the same time,
Explain
the
to
same
me,
date.
explain to me, what is the authority for interpreting that sightseeing statute or sightseeing license as being exclusive? I know it says that, but I think it can mean two things. In other words, exclusive, only the police department and not the city council can give it. Who's interpreted it to say that means there's no review? Is this the first time that's been interpreted this way?
This is the first time that I know of. There's no case law that would suggest that. Certainly, Reardon doesn't suggest that. City of Worcester suggests the exact opposite by saying that the paramount.
You mean no review by the DPU? Is that what you mean?
Right. I mean, one can look at that statute and say, okay, they enacted this thing about the city council issuing street licenses, and now this sightseeing license, which is to be issued sort of exclusively by the police commissioner, could mean not the city council. rather than no right to have it reviewed by the DPU, but like any other such license.
In any other city in the whole Commonwealth, a company that wishes to, for example, do sightseeing in maybe a lesser place than Boston, can get a review. But if we interpret it the way it's being presented today, nobody in Boston can ever be reviewed if the sightseeing licenses is
Well,
Not acted on.
you can, but you
not by this mechanism. I
you
think
can't,
it's
yeah, you can't be reviewed by the DPU, but you could get reviewed.
writ.
Well, no, I mean, you get certiorari,
Right.
Okay, writ of certiorari, right.
right? So you can, I mean, you can get reviewed by the Superior Court or the District Court, VMC.
I think it's
right?
somewhat different, Your Honor. in
But it is
terms
a
of
review,
its-
that's all I'm saying.
I'm not disputing that, but I think that the key is there's a developed system for this very specific thing, and there's no exception taking Boston out of it. Am I over? I'm sorry, Your Honor. Thank you.
Thank you. Good morning, Your Honor. Daniel Hammond, Assistant Attorney General for the DPU.
Why do you say exclusive means that you, the DPU, don't have any authority over it after the police department has failed to act on it?
No, I understand the question, and I think the simplest answer is that Chapter 159A, Section 1, both creates the creature known as the municipal street license and explains the terms on which it's granted by all cities and towns, and also creates the mechanism for the DPU to step in, well, first of all, to review on a quasi-appellate basis any denial by a city or town, but also to step into the shoes of a city or town that fails to act on a application for a municipal street license. This other creature, which is created by what I'll call the session law, statute 1931, chapter 399, section 1, is unique to Boston. The statute doesn't call it a sightseeing license, but in the vernacular, that's what it has been referred to. And that creates jurisdiction exclusively in the Boston Police Commissioner to review and grant that license.
But it doesn't say it's not subject to review, does it?
No, it doesn't say that, but nor does it create a vehicle for review by the DPU as the other statute does. So I think what Nautical Tours attempted to do here, and granted the statutory universe could be clearer, but I think what they're attempting to do is use a remedy specifically provided for municipal street licenses in the vis-a-vis the sightseeing license in Boston, for which it is not an option. And that is what the DPU ruled as a matter of jurisdiction. In the first instance, this is a plain language interpretation by the department. The department looked at what Nautical Tours was attempting to do and said correctly, I would say, that we don't have jurisdiction to hear that. That's why there was no hearing here. That's why the matter was decided on the papers. There were no facts to be adduced. It was simply a question of, does jurisdiction exist?
I noticed these rules and procedures dated January 5th, 2010.
Yes.
Does this fix this problem? Because frankly, it sounds to me like a problem when you can't get an answer from the Boston Police Department on something like this.
Well, yes, Your Honor. I think to a large extent it does. And I think it also speaks a little bit to how, I think it speaks to the double-decker bus problem here, quite frankly. The answer to that, from our perspective, as you see in the brief, is first and foremost exactly what Justice Spina said in his decision for the county court, which is jurisdiction can't be conferred by agreement or by, in this case, estoppel. In other words, if double-decker was wrong, it doesn't make jurisdiction available here. But setting that aside for the moment, if we are to look at the two cases side by side, how are they different? The first critical difference is, as Your Honor just alluded to, when double-decker applied back in 2003, there was kind of a cacophony of voices coming out of the city of Boston as to whether or not the Boston Police Commissioner in fact exercised jurisdiction over sightseeing licenses. And in the double-decker decision by the DPU that's in the record, there's some discussion of the various answers they got from various officials in Boston.
Part of the problem.
Part of the problem. And so, what the department did in exercising jurisdiction over double-decker was first to look to that and say, okay, there's at least some ambiguity as to whether there's anything to get from Boston. And secondly, what we would call on the facts, the de minimis distinction, which is to say that double-decker bus was merely crossing the Harvard Bridge, turning around and going back, whereas Nautical Tours purports to extensively use Boston city streets in carrying out its function. Now, these rules went into effect, as you said, in 2010. There's not a whole lot of empirical evidence as to how they're being applied, but what they do stand for is at least the proposition that the Boston Police Commissioner has unambiguously asserted his jurisdiction over this creature, has set out rules for how to apply, what you need to show, and in fact, what your administrative remedies will be if you get an adverse decision from I believe it's called the Hackney Division. There are internal administrative appeals, ultimately resulting in an appeal to the commissioner himself or herself. And
So do we have any product from this rule at all? Have any licenses been issued under these new rules?
not to my knowledge.
Years ago, huh?
Yes, I mean, obviously it'd be
to get a
helpful
license.
if we could show that it is working as intended. The record doesn't contain any evidence. I'm not aware of any cases out there, but it does at least stand for the proposition that whereas before there may have been something of a vacuum, now there is not. Now there is a clear assertion of jurisdiction by the Boston Police. And so I think that explains the different treatment, if you will, of double-decker versus Nautical Tours. But I also think it explains to some extent how double-decker got in the door in the first place. And that's a situation that no longer exists and did not exist at the time Nautical Tours applied the second time. And the department took notice of that. I think the last piece I would like to address, unless obviously the court has any other questions, is that the Nautical Tours cites in its brief to this court's recent decision in the Bristol County mosquito control case. And what I understand Nautical Tours to be saying is, okay, fine, the plain language says exclusive authority in the Boston Police Commissioner, but the plain language doesn't always mean what it says, particularly where applying the plain language would lead to an absurd or an unanticipated result. And I think that's precisely what this court found in the mosquito control case. If you'll recall, there was a session law or an outside session of the budget that vested sole authority or sole control in the local regulator over salaries of people that it employed. And but there was also pre-existing codified statutory law that gave an overarching state agency control over the budgetary functions of all of the local control boards. And so what the court ultimately said, that I would say that case stands for the absurdity exception to the plain language rule. In other words, if you read the plain language in a vacuum and do what it says, and it creates a result clearly at odds with what the legislature intended or with common sense, don't do it. And in that case, in fact, the court pointed to some kind of parade of horribles of things that would happen if they read the language in a vacuum. In other words, the local board would have unfettered authority to allocate all of its budget to salaries and not actually kill any mosquitoes. And the state board would have nothing to say about that. And the court said rightly that that can't be what the legislature intended. They set up this whole prior regime for review of budgetary decisions by the state authority. And so we're going to go with that. That's not the case here. First of all, the two statutes were passed by the same legislature on the same day in 1931. They created the general regime for all municipal street licenses in every city and town, and the more specific regime for Boston. And as the Reardon case lays out, there are at least rational reasons why the legislature on the same day decided to treat Boston differently. Even in the early 1930s, Boston as a matter of traffic control and a matter of just the sheer geography of the streets and how they're laid out, and the higher density of attractions to view, Boston was different. And I think implicitly what you can read from the statutory scheme that was created on that day is the legislature viewed the regulation of sightseeing tours in Boston more as a matter of public safety than it did anywhere else. Everywhere else you see terms like public necessity, public convenience. In Boston, it's a matter of potentially life or death. You're clogging the streets, you're making it impossible for emergency vehicles to respond, et cetera, et cetera. So therefore, unlike everywhere else, we're going to create this separate vehicle in Boston. We're going to let the police commissioner decide what's safe and what isn't, and we're not going to let anybody else second guess them, including state regulators sitting in an appellate capacity. I think that's rational. I think it's actually what the legislature intended. At a minimum, I think it's not absurd, and therefore it's not analogous to the mosquito control case.
Thank you, counsel.
Thank you, Your Honor.